Good day, I'm Mary Jane Escobar and I'm here to discuss the Module 4 in Law on Obligation and Contracts. So we will discuss the classification of obligations. First, primary classification of obligation under the Civil Code. Pure and conditional obligation. Now, what is a pure obligation? According to Article 1179, in the first paragraph, every obligation whose performance does not depend upon a future or uncertain event, or upon a past event unknown to the parties, is demandable at once. In Article 1181, the conditional obligations, the acquisition of rights, as well as the extinguish or loss of those already acquired, shall depend upon the happening of the event which constitutes the condition. Next, obligations with a period. An obligation is with a period of an interval of time is provided for which either suspends the demandability of an obligation or will terminate an existing obligation. So it is also a suspensive period or resolutory period. Next, alternative and facultative obligations. Alternative obligation is one where several prestations are due but the complete performance of one of them is sufficient to extinguish the obligation, while in facultative obligations, only one prestation is due but the debtor may render another in substitutions. Next, joint and solidary obligations. Joint obligation is when the debtors are bound to perform the obligation together and the creditor may require performance only from all of them together. Solidary obligation is when each debtor is bound to perform the obligation in full and the creditor may require performance from any of them until full performance has been received. Next, divisible and indivisible obligations. A divisible obligation is one of the object of which, in its delivery or performance, is capable of partial fulfillment. An indivisible obligation is one of the object of which, in its delivery or performance, is not capable of partial fulfillment. Next, obligation with a penal clause. In Article 1226, in obligation with a penal clause, the penalty shall substitute the indemnity for damages and the payment of interest in case of non-compliance, if there is no stipulation to the contrary. Nevertheless, damages shall be paid if the obligor refuses to pay the penalty or is guilty of fraud in the fulfillment of the obligation. Second, secondary classification of obligation under the Civil Code. Unilateral and bilateral obligations. Unilateral where only one party is bound and bilateral where both parties are mutually and reciprocally bound. Next, real and personal obligations. Real when the obligation consists in giving something, or personal when the obligation consists in doing or not doing something. Next, determinate and generic obligations. A determinate is a concrete, particularized object indicated by its own individuality, while a generic is one whose determination is confined to that of its nature, to the genus or genera to which it pertains, such as a horse or a chair. Next, civil and natural obligations. Civil obligation is based on a positive law and gives right of action to compel their performance, while natural obligation is based on natural law but on equity and moral justice. Next, legal, conventional, and penal obligations. Legal obligations arises from laws and conventional obligation is arises from contracts with the force of the law, and lastly is penal obligation arises from delicts and criminal offenses. Next, meaning of pure obligations. Is an obligation that is demandable since it has no condition and there is no specific date stated or mentioned. Next, meaning of conditional obligation. A conditional obligation is an obligation that one whose consequences are to comply one way or another for its fulfillment. In short, this is an obligation that is subjected to a condition. Next, meaning of conditional. A condition is future or uncertain event, upon the happening which the effectivity or the cancellation of the obligation is subject to it depends. The characteristic of a condition are it is future and uncertain and past but unknown. Also, it must be not be impossible. Next, characteristic of a condition. First, future and uncertain. In order to constitute an event as a condition, it is not enough that it be future. It must also be uncertain. Second, past but unknown. A condition may refer to past event unknown to the parties. If it refers to a future event, both its very occurrence and the time of such occurrence must be uncertain. Otherwise, it is not a condition. Next, two principal kinds of condition. They are first, suspensive condition or condition precedent or condition antecedent. Are condition which suspends the obligation until the happening of a future or uncertain event. Therefore, the demandability of right is after the condition is fulfilled. Second, resolutory condition or condition subsequent are condition that is existing obligation and terminates the right upon fulfillment. Next, distinction between suspensive and resolutory condition. The difference between the two conditions is very clear. Both bear an influence on the existence of the obligation, but in diametrically opposed manner. First, if the suspensive condition is fulfilled, the obligation arises, while if it is the resolutory condition that is fulfilled, the obligation is extinguished. Second, if the first does not take place, the tie of the law or juridical or legal tie does not appear, while if it is the other, the tie of law is consolidated. And third, until the first takes place, the existence of the obligation is a mere hope, while in the second, its effects flow, but over it hovers the possibility of termination. Next, when the obligation is demandable at once. An obligation is demandable at once, first, when it is a pure. Second, when it is subject to resolutory condition. Or third, when it is subject to resolutory period. Next, past event unknown to the parties. A condition really refers only to an uncertain and future event. A past event cannot be said to be a condition since the demandability of an obligation subject to a condition depends upon whether the event will happen or will not happen. What is really contemplated by the law is the knowledge to be acquired in the future of a past event which at the moment is unknown to the parties interested. For it is only in that sense that the event can be deemed uncertain. This knowledge determines whether the obligation will arise or not. Next, where duration of period depends upon the will of the debtor. A period is a future and certain event upon the arrival of which the obligation subject to it either arises or is extinguished. First, the debtor promises to pay when his means permit him to do so. The obligation shall be deemed to be once with a period. In this case, what depends upon the debtor's will is not whether he should pay or not, for indeed he binds himself to pay. What is left only to his will is the duration of the period. If the debtor and the creditor cannot agree as to the specific time for payment, the court shall fix the same on the application of either party. Next, other cases. As when the debtor binds himself to pay. First, little by little, as soon as possible, from time to time, at any time I have the money, in partial payments, when I am in a position to pay. Next, effect of happening of condition. This article reiterates the distinction between a suspensive or antecedent condition and the resolutory or subsequent condition. First, acquisition of rights. This one is in the obligation subject to suspensive condition. The acquisition of rights by creditor depends upon the happening of the event which constitute the condition. In this one, once the condition is fulfilled, an obligation arises. Second, loss of rights already acquired. This one is the obligation subject to a resolutory condition. The happening of the event which constitute the condition produces the extinguishment or loss of rights already acquired. In other words, once the condition is done, the obligation will be terminated or ended. Next, classification of conditions. Condition may be classified as follows. First, as to effect. We have suspensive, the happening of which gives rise to the obligation, and resolutory, the happening of which extinguishes the obligation. Second, as to form. We have the condition is clearly stated. Implied, the condition is merely inferred. Third, as to possibility. We have possible, the condition is capable of fulfillment legally and physically. And impossible, the condition is not capable of fulfillment legally and physically. Fourth, as to cause or origin. We have potestative. The condition depends upon the will of one of the contracting parties. And casual, which is the condition depends upon chance or upon the will of a third person. And also we have mix, which is the condition depends partly upon chance and partly upon the will of a third person. Fifth, as to mode, we have positive. The condition consists in the performance of an act. And negative, the condition consists in the omission of an act. 6. As to numbers, we have conjunctive. There are several conditions and all must be fulfilled. And disjunctive, there are several conditions and only one of some of them must be fulfilled. 7. As to divisibility, we have divisible. The condition is susceptible of partial performance, and we have indivisible. The condition is not susceptible of partial performance. Next, potestative condition. A condition suspensive in nature and which depends upon the sole will of one of the contracting parties is known as potestative condition. Next, where suspensive condition depends upon will of debtor. First, conditional obligation void. The condition depends solely upon the will of the debtor. There is no burden on the debtor and no juridical tie is created. Second, only the condition void. The obligation is pre-existing and does not depend for its existence upon the fulfillment by the debtor of the potestative condition. Only the condition is void, leaving unaffected the obligation itself. Example: Jane borrowed money from John, payable in a month. Subsequently, she promised to pay after selling her car, where John agreed. The condition is void but the obligation still exists. Next, where suspensive condition depends upon will of creditor. If the condition depends exclusively upon the will of the creditor, the obligation is valid. Next, where resolutory condition depends upon will of debtor. If the condition is resolutory in nature, like the right to repurchase in a sale with pacto de retro, the condition is valid although its fulfillment depends upon the sole will of the debtor or seller. The fulfillment of the condition merely causes the extinguishment or loss of rights already acquired. The debtor is naturally interested in its fulfillment. The position of the debtor when the condition is resolutory is exactly the same as that of the creditor when the condition is suspensive. Next, casual condition. If the suspensive condition depends upon chance or upon the will of a third person, the obligation subject to it is valid. Next, mixed condition. The obligation is valid if the suspensive condition depends partly upon chance and partly upon the will of a third person. Example: X, a building contractor, binds himself to Y to repair at X expense if the building was damaged due to an earthquake judged by a panel of arbitrators. The construction contributed to the damage in any way. Both conditions must happen so that X obligation will arise. Next, where suspensive condition depends partly upon will of debtor. According to Manresa, the use of the word exclusive or now sole makes it clear that conditional obligation whose fulfillment depends partly upon the will of the debtor and partly upon the will of a third person or upon chance are perfectly valid. It is believed, However, that if the compliance with the obligation still depends upon that part of the condition whose fulfillment depends upon the will of the debtor. The obligation is void as it is within his power to comply or not to comply with the same. The situation is the same as if the condition depends entirely upon the will of the debtor. Next, when Article 1183 applies. In Article 1183 refers to suspensive condition, it applies only to cases where the impossibility already existed at the time the obligation was constituted. If the impossibility arises after the creation of the obligation, Article 1266 governs. Next, two kinds of impossible condition. They are first, physically impossible condition. When they, in nature of things, cannot exist or cannot be done and impossible to happen. For example, I will pay you 20,000 if it will not be hot for 1 year in the Philippines. Second, legally impossible conditions are the conditions that are against the law, morals, goods customs, public order, and public policy. For examples, I will give you 15,000 if you will threaten X by shooting their house. Next, effects of impossible conditions. First, conditional obligation void. The impossible condition will nullify the obligation depends upon them. The obligation and the condition are void because the obligor knows that his obligation cannot be fulfilled. Second, conditional obligation valid. The condition that nothing to do an impossible thing because of that, the obligation can be rendered and be fulfilled because nothing to do to impossible things and there's like no condition. The obligation are pure and therefore demandable at once. First, only the affected obligation void. If the obligation is divisible, the part thereof not affected by the impossible condition shall be valid. Second, only the condition void. If the obligation is a pre-existing obligation and therefore does not depend upon the fulfillment of the condition which is impossible for its existence, only the condition is void. Next, positive condition. The above article refers to positive or suspensive condition, the happening of an event at a determinate time, the obligation is extinguished. First, as soon as the time expires without the event taking place. Or second, as soon as it has become indubitable that the event will not take place although the time specified has not expired. Next, negative condition. The above provision speaks of a negative condition that an event will not happen at a determinate time. The obligation shall become effective and binding. First, from the moment the time indicated has elapsed without the event taking place. Or second, from the moment it has become evident that the event cannot occur, although the time indicated has not yet elapsed. If no time is fixed, the circumstances shall be considered to arrive at the intention of the parties. This rule may also be applied to a positive condition. Next, constructive fulfillment of suspensive condition. There are three requisites for the application of these articles. First, the condition is suspensive. Second, the obligor actually prevents the fulfillment of the condition. And third, he acts voluntarily. The law does not require that the obligor acts with malice or fraud as long as his purpose is to prevent the fulfillment of the condition. He should not be allowed to profit from his own fault or bad faith to the prejudice of the obligee. In a reciprocal obligation like a contract of sale, both parties are mutually obligors and also obligees. Next, constructive fulfillment of resolutory condition. Article 1186 applies also to an obligation subject to a resolutory condition with respect to the debtor who is bound to return what he has received upon the fulfillment of the condition. Next, retroactive effects of fulfillment of suspensive condition. First, in obligation to give. It is an obligation to give subject to a suspensive condition becomes demandable only upon the fulfillment of the condition. However, once the condition is fulfilled, its effect shall retroact to the day when the obligation was constituted. The reason is because the condition is only an accidental element of a contract. An obligation can exist without being subject to a condition. Had the parties known beforehand that the condition would be fulfilled, they would have bound themselves under a pure obligation. Hence, the obligation should be considered from the time it is constituted and not from the time the condition is fulfilled. Second, in obligation to do or not to do. With respect to the retroactive effect of the fulfillment of a suspensive condition, in obligation to do or not to do, no fixed rule is provided. It does not mean, however, that in this obligation the principle of retroactivity is not applicable. The courts are empowered by the use of sound discretion and bearing in mind the intent of the parties to determine. In each case, the retroactive effect of the suspensive condition that has been complied with it includes the power to decide that the fulfillment of the condition shall have no retroactive effect or from what date such retroactive effect shall take effect. Next, retroactive effects as to fruits and interest in obligation to give. First, in reciprocal obligations. There is no retroactivity because the fruits and interest received during the pendency of the condition are deemed to have been mutually compensated. This rule is necessary for purposes of convenience since the parties would not have to render mutual accounting of what they have received. Fruits here may be natural, industrial, or civil fruits. Second, in unilateral obligations. There is usually no retroactive effect because they are gratuitous. The debtor receives nothing from the creditor. Thus, fruits and interest belong to the debtor unless from the nature and the circumstances of the obligation it should be inferred that the intention of the person constituting the same was different. Next, rights pending fulfillment of suspensive condition. First, rights of creditor. Bring appropriate action for the preservation of his rights as the debtor may render nugatory or not serious ignore the obligation upon the happening of the condition. It is action for prohibition restraining the alienation of the thing pending the happening of the suspensive condition. It is also have his rights annotated in the registry. Second, rights of debtor. Entitled to recover what has been paid by mistake prior to the happening of the suspensive condition. The creditor may or may not be able to fulfill the condition imposed. He cannot recover what he has prematurely paid once the suspensive condition is fulfilled. According to the Article 1189, when the condition have been imposed with the intention of suspending the efficacy of an obligation to give, the following rule shall be observed in case of the improvement, loss or deterioration of the thing during the pendency of the condition. First, if the thing is lost without the fault of the debtor, the obligation shall be extinguished. Second, if the thing is lost through the fault of the debtor, he shall be obliged to pay damages. It is understood that the thing is lost when it perishes, or goes out of commerce, or disappear in such a way that its existence is unknown or it cannot be recovered. Third, when the thing deteriorates without the fault of the debtor, the impairment is to be borne by the creditor. Fourth, if it deteriorates through the fault of the debtor, the creditor may choose between the rescission of the obligation and its fulfillment, with indemnity for damages in either case. 5. If the thing is improved by its nature, or by the time, the improvement shall inure the benefit of the creditor. 6. If it is improved at the expense of the debtor, shall have no other right but granted to the usufructuary. Next, requisites for application of Article 1189. Article 1189 applies only if, first, the obligation is a real obligation. Second, the obligation is a specific or determinating. Third, the obligation is subject to a suspensive condition. Fourth, the condition is fulfilled. And 5, there is loss, deterioration, or improvement of the thing during the pendency of the condition. Next, kinds of loss. Loss in civil law may be, first, physical loss. A thing perishes as when a house is burned and reduced to ashes. Second, legal loss. Goes out of commerce or disappears. Example, when legal becomes illegal. Third, civil loss. disappears in such a way that its existence is unknown or it cannot be recovered. Example, when a diamond ring dropped into the sea. Next, rules in case of loss, deterioration, or improvement of thing during pendency of suspensive condition. First, loss of thing without debtor's fault. The obligation is extinguished. In general rule, a person is not liable for a fortuitous event occurred. Second, loss of thing through debtor's fault. If the loss is due to negligence, the creditor is entitled to demand for damages. Third, deterioration of thing without debtor's fault. Deterioration is when its value is reduced or impaired. In this case, without debtor's fault, therefore the debtor is not liable for the damages and the creditor will have to suffer of the deterioration. Fourth, deterioration of thing through debtor's fault. There is two choices to choose. First, the rescission or cancellation of the obligation with damages. The debtor is liable to pay for the thing and the incidental damage due to deterioration. Second, is to fulfill the obligation and also to pay the damages. 5. Improvement of thing by nature or by time. There is improvement if the value of it is increased or enhanced by nature or by time. In this case, the creditor gets the benefit of the improvement. 6. Improvement of thing at expense of debtor. In this case, the debtor is having the benefit of improvement while using the thing belonging to another. Usufruct. The right to enjoy the fruits of the thing belonging to another. Next, effects of fulfillment of resolutory condition. First, in obligation to give. In resolutory condition, when the obligation is fulfilled, the obligation is extinguished. The parties are obliged to return to each other what they receive under the obligation. There is a return to the status quo. In other words, the effection of the fulfillment of the condition is retroactive. Second, in case the thing to be returned is legally in the possession of a third person who did not act in bad faith. The remedy of the party entitled to restitution is against the other. Next, the obligation of mutual restitution is absolute. It applies not only to the thing received, but also to the fruits and interest. And last, in obligation to give subject to suspensive condition. The retroactivity admits exception according as the obligation is bilateral or unilateral. The reason for the difference is quite plain. The happening of the suspensive condition gives birth to the obligation. On the other hand, the fulfillment of the resolutory condition produces the extinguishment of the obligation as though it had never existed. The only possible exception is when the intention of the parties is otherwise. Second, in obligation to do or not to do. The courts shall determine the retroactive effect of the fulfillment of the resolutory condition. The courts may even don't allow retroactivity in each cases. Next, applicability of Article 1189 to party with obligation to return. The fulfillment of the resolutory condition moves the creditor into debtor and vice versa. Therefore, there will be an applicability of the provisions of Article 1189 in case of loss, deterioration, or improvement of the thing. Pending the fulfillment of the condition, the debtor and the creditor are entitled with rights of Article 1188. Next, kinds of obligation according to the person obliged. They are unilateral. There is only one party is obliged to comply with an object or prestation. Bilateral, both parties are obliged to comply with each other. Both are debtor and creditor of each other. It can be first, reciprocal obligation. This is an obligation which arises from the same cause and both parties are debtor and creditor to themselves. This is an act wherein the performance of the debtor is equivalent to the performance of the creditor and vice versa. And non-reciprocal obligations are those do not impose that the performance of both parties are simultaneous and correlative. The performance of one party do not depend upon the simultaneous performance of the other party. Next, remedies in reciprocal obligations. First, choice of remedies. In case one of the obligors does not comply with what is incumbent upon him. The aggrieved party may choose between two remedies. First, action for specific performance or fulfillment of the obligation with damages. Or second, action for rescission of the obligation also with damages. Next, remedy of rescission for non-compliance. Principal action must be distinguished from the subsidiary action for rescission by reason of lesion or damage under Article 1381 and from cancellation of a contract based and not on violation by a party of his obligation. Article 1191 governs where there is non-compliance by one of the contracting parties in case of reciprocal obligations. The remedy is granted for breach by the other contracting party that violates the reciprocity between them. Next, court may grant guilty party term for performance. The court shall decree the rescission claim unless there should be just cause for granting the party in default a term for the performance of his obligation. Next, remedies are alternative. The remedies of the injured or aggrieved party are alternative and not cumulative. He is privileged to choose only one of the remedies and not both. He may also seek rescission even after he has chosen fulfillment if the latter should become impossible. But after choosing rescission of the obligation, he cannot thereafter demand its compliance. Next, limitation on right to demand rescission. Right to rescind by the injured party or the one who has performed what is incumbent upon him is not absolute. First, resort to the courts. Rescission contemplated by Article 1191 is a judicial rescission. The injured party must resort to the courts to assert his rights judicially, for the same article provides that the court shall decree the rescission demanded unless there be just cause authorizing the fixing of a period. No person can take justice in his own hands and decide by himself what are his rights in the matter. Other party must also have an opportunity to be heard. Second, power of court to fix period. The court has discretionary power to allow a period within which a person in default may be permitted to perform his obligation if there is a just cause for giving time to the debtor. Third, right of a third person. Rescission creates the obligation of mutual restitution. If the thing or subject matter of the obligation is in the hands of a third person who act in good faith, rescission is not available as a remedy. Or substantial violation. Rescission will not be granted for slight casual breaches of contract. The violation should be substantial and fundamental as the defeat the object of the parties in making the agreement. 5. Waiver of right. The right to rescind may be waived, expressly or impliedly. The acceptance by the seller of the land sold as security for the balance of the price is an implied waiver of the right to rescind in case of non-payment by the buyer. His remedy is to recover the balance. Next, rescission without previous judicial. First, where automatic rescission expressly stipulated, the parties may validly enter into an agreement that violation of the terms of the contract would cause cancellation thereof even without judicial intervention or permission. Contract itself contains such stipulation, right to receive is expressly recognized by the parties or not complied. Second, where contract still executory. There is no performance yet by both parties, but one is ready and willing to comply and the other is not. The willing party may, by his own declaration, resign the contracting without a previous judicial decree of rescission. In such case, it is not necessary that there be a stipulation providing for automatic rescission. In any case where the extrajudicial rescission is contested by the other party, he is free to resort to judicial action, and only the final decision of the court can finally settle whether the rescission was proper or not. Next, where both parties are guilty of breach. First infractor known. The liability of the first infractor shall be equitably reduced by the court. But if the first infractor cannot be determined, the contract shall be extinguished and each party shall be liable for their own damages. Second, first infractor cannot be determined. One party violated his obligation followed by the other, but it cannot be determined which of them was the first infractor. The rule is that the contract shall be deemed extinguished and each shall bear his own damages. This means that the contract shall not be enforced. So that's it. Again, my name is Mary Jane Escobar, and this is my discussion in Module 4, Obligation and Contracts.